Happy New Year. So it's strange saying Happy New Year in the beginning of February, but in any event, it's the first time we've all been able to get together. So for us, it's the start of the new year. What's been happening over Christmas and so on with the in the law? Well, as you may imagine, not a great deal. All the judges go on holidays, but mind you, just before Christmas they tend to try and get their judgments out in a big rush, the ones they should have been doing during the year. But I don't think there was much that was of great impact for you guys. One thing that does, however, impact you, those of you at any rate who provide expert witness services, and that is that there is a new expert witness code of conduct. Came in on the 9th of December 2016, so 9th of December last year. It means that those who are instructing you will need to give you a new version of the code of conduct. It's not hugely different from the old one, but there are some differences which I'll explain in a minute. But again, just to say, if you have your own copies of the Expert Witness Code of Conduct under the Uniform Civil Procedure Rules that you have from pre-9 December 2016, you're going to need to get a new copy, because it is new. And if you attach the old one, well, not only might there be some embarrassment, but there might be some question as to whether your report is admissible. So the differences, they are largely semantic, but there are some more substantive differences. So firstly, where you've provided a report and you sometime between the provision of the report and the time it goes to court, you change your mind, or whether on the whole thing or an aspect of your previous report, you must immediately provide a supplementary report that states what the difference is between and why you changed your opinion. Also, you need to make sure that your reports to the court, so where you're required to report to the court, that is provided in a timely manner. Otherwise, and this is to address issues where reports breach the timetable that's been set by the court. So you need to abide in any, you are agreeing expressly to abide in a timely way by any direction of the court. So that's to address issues faced by trying to finalise joint reports and then delaying the whole court process. So in a conclave, you'll agree to abide by any direction of the court expressly. Also, where you are, you have to make a declaration that you've made all your inquiries that you believe are desirable and appropriate, and expressly say that no matters of significance that you regard as relevant to your knowledge has been withheld from the court. That's slightly different to what you had to do before. You actually have to say that you've made all inquiries which you believe are desirable and appropriate. Lastly, but quite importantly, it's something that happens regularly, if there is a conclave and you fail to reach agreement on any particular issue, or it could be the whole thing, but if you fail to reach agreement on any issue, then each of the experts has to endeavour to identify and clarify the basis of the disagreement and put that in the joint report. So previously it was, these are the areas we agree on, these are the areas we disagree on. Now, if you disagree, you have to say why you disagree and the basis of your disagreement. So that needs to go in the joint report. So they're the main differences with the new Expert Witness Code of Conduct. Don't get caught out with that. Now, not long after our Christmas party last year, which was great, and thank you to the executive for putting that on, I got an email from Joe, who was forwarding an email from Steve Natler, who was asking some questions about subcontracting. So, the first question was, do we need a legal agreement if we are subcontracting pre-purchase pest and building inspections to another inspection company? Do we need one? You don't have to have one. My recommendation is that you certainly do have one. First and foremost, if you have a contract with whoever it is who's retained you to do the report, if you are going to subcontract, you ought to get their permission anyway. But it's an issue of liability. If you've got somebody else out there doing the report, you're still liable to your client, and if that person stuffs up that report, well, the liability is going to come back to you on a contractual basis. My recommendation is that yes, you certainly do have an agreement, a contract with your subcontractor, and the very important provision in that will be that the subcontractor indemnifies you against any claim that's made against you by your client. Otherwise, you might find yourself trying to recover from your subcontractor, recover damages, and back to back, it's like your scope of what you are covered for is much less if you are just trying to claim damages for negligence than if you have a contractual indemnity. So, and apart from anything else, there's certainty that arises. There's less room for dispute between you and your subcontractor and you and your client. So if the terms of the subcontract on which you are subcontracting are set out clearly in a document, then that's far, far better, and you'll spend far less time in dispute if you have one of those. Second question was, how do insurances work in this scenario? Short answer is you'll need to check your insurance policy. I'm not sure whether your professional indemnity policies cover the acts of subcontractors. They certainly cover the acts of employees, but whether they cover subcontractors, I don't know. You'll need to check your insurance policy. And of course, with your subcontractor, I'll be checking to make sure your subcontractor's got an insurance policy as well, for obvious reasons. Your liability, the next question is, what is our liability? Well, as I say, you have a contractual liability to your client. So if it goes wrong, you are contractually liable to your client. There may also be some liability negligence on your part, but usually your client will come after you on a contractual basis. Just to round that out, if somehow some third party is affected by your subcontractor's negligence, then provided they are actually an independent contractor, you won't be liable to that third party. You're only liable contractually to your client. So that can be everything from if when he's out there, his car rolls out of the driveway and hits a car coming down the street. That's his problem. It's not your problem. Conceivably, if he misses something and some third party relies on that pre-purchase report, then again, that's his liability to that third party. It's his negligence. You're not contracted to that third party, so you're not responsible for the negligent acts of your independent contractor. So there is some protection there, provided, of course, that when the report is actually produced, it's got his name on it, not your name on it. If it's got your name on it, well then you might be seen to be endorsing that report, in which case you may well be liable to that third party. So that's something to think about as well. And finally, is there a standard agreement that could be provided for this scenario, or do we have to organise a meeting with the solicitor to draft it? I sort of always recommend you see your solicitor. Surprise, surprise. Look, there are standard subcontract agreements out there. I'm not aware of a standard subcontract for pre-purchase pest and building inspections specifically. There are certainly general subcontract agreements out there. The MPA produces one. Standards Australia produces a subcontract agreement. I would suggest though, and I'm sincerely not just trying to drum up business, but I would suggest that you'll be better off having one tailored for your business. It's not a huge exercise. It's I was about to say it's not going to be terribly costly. Of course, everything is relative. I would have thought that you could get a subcontract agreement drawn up for somewhere between $500 and $1,000 in normal solicitors fees. That would be my guess. Because we did, when I say we, my firm several years ago did draft a contract for members of the society to use with their clients. We weren't asked to look at a subcontract to go with that agreement. Be happy to have a look at that if that's something that is going to be of use to the society and something that's going to you do regularly as in the subcontract. So that's about it. Is there any questions around that or further questions around subcontracting?
Can I just ask, what's the new number for the code of conduct for the for NCAT? You said the code of conduct has changed.
Yeah.
Has that got a new number?
No, it's not, there's no new number, so it's just that it's the same schedule. So it's still Schedule 7 of the to the Uniform Civil Procedure Rules. They've actually amended the schedule itself. Yeah. And that, I guess that could be the source of confusion because it's a Schedule 7, but you've got to check it's the up-to-date one.
Does it apply equally to the courts and NCAT?
Yes, it does.
Excuse me. A client engages company A.
Yep.
Company A engages subcontractor.
Yep.
The subcontractor goes on site, writes the report.
Mm-hmm.
Who puts into the client? Normally, it should be the first company A.
Company A, yeah.
Correct? Now, in the Act, it says that the person must be suitably qualified to do this job.
Sorry, which act are you talking about?
So, qualified to do whatever the subcontractor is doing.
Well, pre-purchase building inspections, they're not regulated under the Act.
So what I want to ask is what it means suitably qualified.
Well, that's how long's a piece of string? I mean, that's one of the reasons for this society that building inspectors aren't regulated by legislation. There was a proposal when the Home Building Act came in that there was going to be some kind of specific licensing, but that fell away. The government didn't have time to do it, and so that's the reason we have societies like this to try and raise the standard and give the consumer some confidence that the person who is doing the inspection is suitably
I
qualified.
think this is the point that I will ask you, I was coming to, that if this is the society that it will raise the standard or give the reputation to our consultants to do the job,
Yep.
shouldn't we approach to the government and say, here we are, please recognize us?
Sure. That's you can lobby the government and I mean there is, I guess, to some degree some level of recognition if you get into the professional standards scheme, which limits liability. Neil Monteith went uphill and down dale with that, very difficult to do. They require all sorts of things, and it's on a slightly different. It's a slightly tangential because that's about limiting liability rather than advertising or breaching a particular standard. There is, with the new strata laws, as I've mentioned before, with the new strata laws, when a developer builds a development, there's a requirement to have an authorised building inspector go along and have a look. Now, they're going to be accredited by the government. You have to go to the government and say, you know, am I a part of that? So that's, I guess, a level of certification or a standard that you could put on your letterhead or whatever.
We're not there yet, probably.
Not there yet. Any other questions? Okay, thank you, gentlemen.
Thank you.
No.